Good evening to the students of the SLW646, that is Advanced International Dispute Settlement Law is concerned. And I don't know whether I posted or not, the 8 questions which I already prepared it for your test. And here I could show you in the embodied nutshell the question bank. Yes, I said that's a question bank. Yes, you could see the question bank now on the screen. Could you see the question bank on the screen, SLW646?
Yes, Prof.
Total, how many are there?
Uh, 9 questions.
9 questions are there. See, one of the questions that I would like to make the repetition. What are the methods of negotiation? I mean, peaceful settlement in a diplomatic way, or non-legal way. If you see the syllabus, and you will understand. Yes, I will show you the syllabus now. Here, the wordings are different style they made it. Yes, if you happen to see settlement of dispute by non-litigation means, litigation means through the court. Am I right?
You are right, Prof.
And the non-litigation means is a diplomatic method. Or we can say also negotiation, mediation, conciliation, diplomatic means, good office, inquiry, findings, all the things will come under the non-litigation. Is it clear?
It is clear, Prof.
Yes. So I already sent you the non-litigation, how the cases would be there. This is the thing which is, I will post you 8 questions, and I opened the file, but when I arbitration, the handbook, it is there. Oh, this is changed. Undo. Just a minute. I'm searching for that one. Yeah. Here, I send this soft copy to you. And this is about, I will scroll it up so that you could know it. What is this? This is the copy which I sent to you, the soft copy. And everybody is having. This is the copy regarding the handbook on the peaceful settlement of dispute between the states. Is it not? Did you receive this in your email? Yes? Dorcas,
Yes, Prof.
this book, did you receive in your email? You are
Prof,
not
I did
giving the
not
answer
check.
to my question. This book, the electronic version, I sent to you in the email. Did you receive it?
I did. Prof, I did not check. I'll see if it is there tomorrow morning.
What is the use of sending the things to your email? Very long back I sent it. From time to time when I finish the things, I will send you the email. Such things. And there you will come across the thing which I want to. This is the institutional related aspect. But I want to see, I already opened it, but when I open the another thing, it has gone. So it doesn't matter, I can trace it out by using my own means. Control F. It is the settlement by the UN Charter. Settlement by UN Charter. Later, it is there. Oh, it is not showing the things. Mediation, conciliation, and other things are there. Yeah, a total Organization of American States, and that thing. African Union, African Unity, we dealt it from the regional, from this only, and we also dealt with the European Inter-American system also from this book only, and again we are a League of Arab States, also I dealt from this book only. So his book is very important because it deals about the peaceful settlement of the disputes among the states are concerned. So peaceful settlement of disputes, of course, articles also he has given, the international charter, but I would like to share today the diplomatic way or non-litigation way of dispute settlement that I want to make it out. That's why I opened it, but when I opened the other thing, it has disappeared. So that is the thing which has happened. Yes, but I am tracing out now and I will get it soon. No matter. The functions, no, it is not the functions, it is. Yeah, when you see this heading, you will come across it. Institutional and related aspects. Institutional means good office also comes. Am I right? It is a non-diplomatic way of dealing the things. So institutional and related aspects, the initiation of the procedure, there will come the good offices may be set out in the motion as described in the paragraph 101 above, and we need not worry about what the paragraph would be there. But what we want to know it, the third party exercising the good office normally establishes the contact with the parties to the dispute through the number of informal meetings with each party, during which the ascertain the position of the both sides and then transmit to the parties each other's position with respect to the dispute. Today I would like to throw light on this aspect actually, which is nothing but mediation, negotiation, reconciliation, and good offices. These are the aspects that I would like to throw light in today's class. So this is about the mediation is there, but I got the nutshell in manner, all the things non-diplomatic way, that is this is the procedural and institutional aspect it is. Not that we are going to deal the provisional institutional aspect, but we are going to deal non-litigation method of the dispute settlement, that we are going to deal it. So there I kept it, but when I opened the another file, it is disappeared. The peaceful means of the charter, this is the UN Charter. This conciliation is the UN Charter, the separately E is given, but the nutshell is given in one aspect of it where we can go through it. In nutshell it is given because it is given in a very high manner. In oh, this is not moving. Yeah, this is the, now I want to make it down to see whether how many are there. Mediation, then 24 has come, Organization of the American states, we dealt it. Organization of the African unity, we also dealt it because these are the regional unities. And Conference of the Security Cooperation Unity, well, no, we did not deal it because we dealt only the European Union. League of Arab States, we dealt it from this book only. Organization of the African Unity, yes, we did from this book only. Then the European Union also, we did from this book only, especially how to deal it. Peaceful settlement of the dispute, this is the charter, this is, especially this is a charter, but we don't want to go to the charter details, but we want to go to the only those details which are what we needed it. I don't know where I kept it. Anyway, that I will trace it because it comes to the declaration, mediation, conciliation, collective negotiations, steps and facilitating negotiations. No, this is not that. See, these are the functions, but we are not dealing the functions. We want to deal only here the mediation characteristic we have given, but we dealt it the characteristic mediation in a beautiful manner, and procedural aspect also we dealt it in the earlier classes. But in these classes, I would like to take the non-litigation method of dealing the thing, and where it comes. Functions is the mediation functions only. No application of method, we are not going to deal this one. And the institutional related institutions and related aspects, institutional adjustment here. But institution of the process, no, we are not going to deal this thing also. Role of procedure also we are not doing. And the expenses, no, these are all not also we are going to deal this one. Arbitration, this is one of the thing of the making the things, mediation, arbitration. And in a nutshell, that we would like to deal institution related aspect. Yes, this is the thing which I want to, no, not this thing exactly. Composition, they are saying no, we don't want to deal the composition. A rule of procedure also we don't want to delete. And the seat and arrangement, no, this also not needed for us, our studies. Outcome of the arbitration in the detailed manner, it is again judicial settlement is there. Yes, we do have the judicial settlement. Judicial settlement means through the, see, I will show you the judicial settlement. Okay, at least we will deal this thing today in my class. Yeah, again we can repeat it, that thing, before we can go to the other aspect of it. See, the judicial settlement, we can make it out in this area where we can make it out. See, this is the adjudication. And the court tribunal is nothing but judicial settlement. Are you following me?
Yes, bro.
Yes, tell me,
Yes, bro.
settlement of the dispute by the adjudication means nothing but judicial settlement. Am I right?
You're right, Prof.
But you have to give the answer. Okay, let me see that today this thing, because actually I want to open that thing, but let you concentrate on today class in judicial settlement. So how the international dispute will be resolved with the judicial settlement. Main characteristics of the legal framework and the function, if you want to see it, state parties to dispute may seek a resolution by submitting the dispute to the pre-constituted international court or a tribunal composed of the independent judges and whose tasks are to settle claims on the basis of the international law and render the decision which is binding upon the parties. Let me explain this point. State parties to dispute. Which dispute? International dispute. And where the people are the parties to a particular instrument or the charter or the protocol. For anyone, the state parties to the dispute may seek a solution. What solution? Remedy. By submitting the dispute to they have to submit to a particular body, institution, that they will bind to the judgment of that judicial organ. and dispute to the pre-constituted international court, international court of justice are concerned, or international tribunals are concerned under the charter. Tribunal composed of the independent judges, and these judges are the independent because we discussed there all the agencies, all the institutions, all the judges, they are having the privileges and immunities, and we discussed it. So they are the independent judges, and whose tasks are to settle the claims. How they settle claims? They settle the claims on the basis of the international law and render the decision which are binding upon the parties. They follow the international laws, international instruments, and the charters, protocols, what they agreed, and where the two states are the parties to it. Based on that thing, without fear and favor, the judges will give the decision and adjudicate it, and that would be the binding upon the parties, those who submitted their jurisdiction to a particular court or judicial organ. Is it clear?
Yes, Prof.
This method is generally referred to as a judicial settlement. Judicial settlement means court settlement. Non-judicial settlement means diplomatic methods. What are the all the things will come: mediation, arbitration, reconciliation, good offices, all the things will come over there. Okay, this now judicial settlement, how it can be done, we'll see it. Which constitutes one of the means of the peaceful settlement of the international dispute set out in the Article 33 of the Charter of the United Nations. So where this is inserted, it is inserted in the Article 33 of the Charter of the United Nations. What settlement? Judicial settlement. Repeat. Participate,
Judicial
repeat.
settlement. Judicial settlement is inserted in Article 33 of United Charter.
Yes. To whom? To the parties, those who are the members of the charter. Is it clear?
It is clear,
Or
Prof.
any international instruments. Not necessarily charter. Charter made by the UNO. But the other instruments will be made by the parties, regional agencies, and the bodies, either multilateral or the bilateral. Treaties are there, protocols are there, and they will be the parties to it. So now, the first international court of worldwide scale was the Permanent Court of International Justice, which was created by the Covenant of the League of Nations in 1922. At the time, League of Nations is the first beginning. At the time, it is the Covenant of the International Justice, the Permanent Court of International Justice under the League of Nations in 1922. It was succeeded by the International Court of Justice. Now the Permanent Court of Justice is changed as a International Court of Justice. Is it clear?
Yes.
Which is established in 1946 as a principal organ of the United Nations. Where this International Court of Justice is there? Mbeya. Where it is
No.
situated?
Switzerland.
It is there in the Netherlands, The Hague places. Once I have shown you also, my daughter went to the Netherlands and went to the International Court of Justice, and he has shown that Tanzania name is there because he is a member to the UN Charter. So the Tanzania name is engraved on the stone. So all the countries whose names are engraved, countries who are the member of the UN Charter of this, they engraved with the year also there in the stone. Yes, under the Article 36 of its statutes, the International Court of Justice has a general jurisdiction in all the cases which the parties refer to it and all matters specially provided for the Charter and the United Nations. Just before we saw the one Charter, Article 33. In the 33, if any matter will be settled through the judicial organ can be done. But in the Article 36 clearly mentions if any state will come to the decision, come to the rescue of any statute in the International Court of Justice, they have the jurisdiction in all cases which the parties refer to it in all matters especially provided for in the Charter of the United Nations. Because whatever the United Nations Charter has kept it, and where the parties are the members to the Charter, then such thing will be dealt by the International Court of Justice by virtue of the Article 36. Is it clear?
Prof, I did not get you. May you please repeat?
Okay, I will repeat it. Article 33 says a decisions will be given by the judicial bodies or the organs, means courts. That is Article 33. The method is generally referred to the judicial settlement, which constitute one of the means of the peaceful settlement of the international dispute set out in the Article 33 of the Charter of the United Nations. Article 33 clearly shows a peaceful and amicable settlement could be done through the judiciary by the virtue of the Article 33 and the UN Charter. Is it clear?
Yes.
That is number one. So Article 36 it says here, Article 36 of its statute, the International Court of Justice has a general jurisdiction. It is having a general jurisdiction to entertain the cases of the states who are the members of the UN Charter in all matters. Jurisdiction is given into the Article 36, and International Court of Justice is one of the judicial organ to resolve the disputes is given in the Article 33. Is it clear?
It is
To
clear,
resolve
Prof.
the disputes of the international and the UN Charter, Article 33 will make the judicial settlements, and Article 36 make jurisdiction of the International Court of Justice to deal all the member states in all matters to settle amicably in the peaceful means. So please remember Article 33, which makes clear the judicial organ can settle the dispute, and Article 36 gives the jurisdiction of the International Court of Justice, that is the judicial organs, judicial education, to entertain such cases. Is it clear, Dorcas?
Yes, Prof, I understand now.
Yes, that is only the difference. Jurisdiction will be shown in the Article 36. Judicial decisions will be given by the judicial organs in 33. Here the judicial organ of the UN is International Court of Justice. What is the earlier name for the International Court of Justice under the League of Nations? It is there on the screen. You did not observe it. Permanent Court of International Justice. Did you see it?
Yes.
It is there on the screen. Under the League of Nations, that is 1922. But under the Charter of the 1946, it becomes the International Court of Justice. Is it clear?
Yes, Prof.
Yes, but both the judicial settlement and arbitration make recourse to an independent judicial body to obtain the binding decision as pointed out in the previous section. I told you also, the disputes can be resolved by the judicial decisions, number one. And the international disputes also amicably resolved by the arbitration. Am I right? In the same manner, both are binding. Arbitration can be done by the regional agencies or the special tribunal established by the charter or the protocol or the treaty. It will deal the cases. Like International International Tribunal in the UK that has decided the case of Dawson case versus what is this electricity department. What is that electricity department? In Tanzania. Participants, electricity department in Tanzania, what do you call? There is a what is it? The Ubungo.
It's called TANESCO.
TANESCO. Dawson's versus TANESCO case law, did you hear? It is decided by the International Court, International Tribunal in the UK. And TANESCO filed the case in the Court of Appeal, first the High Court, later in the Court of Appeal. But they said, when the parties agreed together for the International Tribunal for resolving the disputes are concerned, at that instance, when the decision is given by following the natural and fair means, neither the High Court of Tanzania nor the Court of Appeal of the Tanzania to have entertained to change the decision when the tribunal has given the decision in fair means, because both the parties agreed to the International Tribunal. That is the decision is given. I don't know whether you studied that case law there or not.
We studied it in private international.
Yes, that's why I'm saying. So, tribunal decision also binding and the judicial decision also binding. That is the same thing it says. Both the judicial settlement and the arbitration make the recourse to an independent judicial body to obtain the binding decision as pointed out in the previous section. Earlier section they did it. Arbitral tribunals, however, are essentially of an ad hoc nature and are composed of judges selected on the basis of the parity by the parties to a dispute, who also determine the procedural rules and the law applicable to the case concerned. Even the tribunal's decisions are binding. International courts and tribunals, by the contrast, are pre-constituted as much as they are permanent judicial organs whose composition or the jurisdictional competency and procedural rules are predetermined by the constituted treaties. Any treaty which created such a tribunal, it gives the full power of the procedural rules, jurisdictions, and competency. Furthermore, judicial settlement may be distinguished from the arbitration in that the decision of the international courts and tribunals are, as a rule, not appealable. See, they are not appealable. Once the decision is given over there, that is the final decision. The statutes of the International Court of Justice provides in its Article 60 that the judgment of the court is final and without appeal. So another article has come into the emergence, Article 60. If the International Court of Justice has given a judgment, that is the final and no appeal. By virtue of Article 60 of the UN Charter. Is it clear?
Yes, Prof.
Article 33 says judicial organizations are there which will decide the cases, means International Court of Justice. Article 36 says 33 judicial organs are there which will entertain the case. Article 36 says jurisdiction of the International Court of Justice, who are the parties to the treaty or charter, and they will entertain such a case. Article 60 says if any decision is given by the International Court of Justice, that would be the final. So the judgment of the courts is final without appeal. The only expectation to the rule concerning the question of the scope and execution of the judgment, which may be subject to the further decision, though the same court, you can review it. You can file for the review. Are you following me?
Yes, Prof.
Thus, Article 60 of the ICJ statute provides further that in the event of the dispute as to the meaning and scope of the judgment, the court shall construe it upon the request of any party. Suppose if they feel that there is a lacuna would be there in the understanding the substantial of the provisions, at that instance they may ask for the review by the request of the parties. But the International Court of Justice decision is the final, but it can review its own decision. For instance, can the Court of Appeal review its own decision? Answer is yes.
It can, Prof.
And it can overrule its own decision also. Am I right?
Yes.
It can overrule its own decision because they say we did not observe a particular aspect of it. Now we are overruling that judgment of given over there. They can make it out. Even the High Court. So the degree of the finality of the decision of the arbitral tribunal, on the other hand, depends upon what is specifically agreed upon in compromise, which may provide for the possibility of the decision being subject to an appeal before the international courts. Generally, the arbitration will be the settlement in the form of compromise, because they don't want to drag the litigation for a longer time. They want to see the reconcile and see that party will agree to the particular point, and they will decide the case, and they will see the case would be no more would be there, it will be dismissed. Not dismissed, the case would be disposed. And the international tribunals are always the compromise mode. But in the International Court of Justice, they will see the substantial law and they interpret the law where the parties are agreed to the contract by following the contract agreement. So it may also be pointed out that because of the international courts or the tribunals are pre-constituted institutions, they are ipso facto better suited than ad hoc arbitral tribunals. So generally, which are pre-constituted, which are very much better to deal such a cases and resolve the issues, and which take longer to constitute to deal with the urgent matters such as the request for the interim provisional measure of the production. Instead of creating a new arbitral tribunals, better we can use the pre-existing tribunals or the International Court of Justice or the adjudicating judicial bodies to see that problem would be resolved. Moreover, owing to the same characteristic as a permanent institution, an international court such as the International Court of Justice appears to be the better suited for the developing the uniform jurisprudence of international law than ad hoc arbitral tribunal. It is more better to deal the cases in the judicial organ, which is nothing but the International Court of Justice, instead of basing on the ad hoc arbitral tribunals. If the parties agrees to the tribunal, both the parties, without any condition, let the tribunal will prevail it to resolve the issue instead of going to the International Court of Justice. So such jurisprudence is developed by the courts while exercising a jurisdiction of contentious cases between the states. So now the jurisprudence is there. Either the party could go for the arbitral award by submitting themselves, or they can resolve the issue by the judicial organs, which is nothing but the International Court of Justice, which is based on the legal instruments, international instruments, and the parties, those who are agreed to the contract. Our advisory jurisdiction on a legal question referred to it by an international organizations and relating the dispute between the state. So ICJ not only give these decisions between the states resolving the international dispute, it can also give the advisory jurisdiction when such a legal question arises between the states relating to the disputes between the states and international organization, and those between the international organization, either between the state or the state and the international organization, or vice versa, and thus settlement of the dispute could be done by the adjudicating bodies or judicial bodies. As the principal judicial organs of the United Nations, the International Court of Justice has also quasi-appellate jurisdiction for the decision of the administrative tribunals established within the United Nations system. So it is having the dual nature. One is, the clearly it says it is a judicial body, which one? International Court of Justice, but it is also a quasi-appellate jurisdiction for the decision of the administrative tribunals. For the decision of the administrative tribunals, it will act as a quasi-appellate jurisdiction and under the United Nations system. So dual rule is there. One is judicial decisions, another is for the administrative tribunal, it could act as a quasi-judicial body, jurisdiction. So this pre-constituted forum, whether of a regional or worldwide scale, or appears also better suited to the arbitrary tribunals to rule the question of the international law raised in cases before the domestic courts, thereby exercising the secondary jurisdiction where such a jurisdiction is conferred. We can resolve the disputes by two means: either approaching to the tribunal and following the international instruments and a particular charter, rules and regulation, with that a tribunal is created, and that will be the binding when the both party agrees to it. Or they can go for the judicial decisions by tapping the door of the International Court of Justice to getting a legal disposition of their claim based on the legal instruments plus UN Charter. So these are the two ways we can resolve the dispute. But the International Court of Justice will do a judicial organ business transaction as well as the administrative tribunal. It could act as a quasi-judicial jurisdiction also under the UN Charter. So that was what I want to impress upon you. So resort to the judicial settlement. A brief analysis of both the Permanent Court of International Justice and the International Court of indicates that of the cases referred to the courts for the judicial settlement, many involve the question of interpretation and application of the treaties. So the interpretation of the law, the interpretation of the treaties and application of the treaties are the concern specific problems such as those relating to the sovereignty over certain territories and frontier the disputes. So all the aspects will be covered and seen. The judicial settlement, those concerning the maritime limitations. Maritime means the admiralty limitation and the other laws of the sea disputes. Even the sea disputes are concerned. And choose arising from the law of diplomatic protection of nations. Even the diplomatic protection of the nationals abroad, even that issue also can be tackled. Or those arising from the circumstances related to the use of force. If any of the use of force would be used over by the another state to a sovereign state, at that instance, a sovereign state who are victim of the harassment of the another state can approach to the ICJ for getting the disposal of the cases. and cases involving the enforcement of the contracts and violation of certain principles of customary international law. So these are all the things a international court of justice having the jurisdiction to entertain such a specific problem arises. What A? Those relating to the sovereignty over certain territories and frontier disputes that can be entertained, and those who concerning the maritime delimitation and other laws, means maritime laws or conflicts or sea disputes, that also could be entertained. C, those arising from the law of diplomatic protection of the national abroad. So a diplomatic protection should be given to the people, those who are staying in the abroad. Even that thing also can be tackled. Those arising from the circumstances relating to the use of the force. If any other force will be used by a dominant state to the weaker state, that can also be entertained by the International Court of Justice as a adjudicating body. Cases involving the enforcement of the contracts. If the contract enforcement is there and a violation of certain principle of customary international law is concerned, even that case also will be handled by the ICJ in the adjudication of the cases. So at any time the Cisco WebEx may stop, but we have dealt today the judicial settlement, how the International Court of Justice under Article 33, Article 35, Article 60 of the UN Conventions will deal it. In addition to that, International Court of Justice also deal the cases of judicial nature. It can also be a administrative tribunal. It is a quasi-judicial jurisdiction also it is having. So these are the things that we studied in today's class. Yes, Dorcas.
Yes, Prof.
So here institutional and procedural aspect, here how it can be done, and special agreements are there, and how the dispute can be settled. And this book I already sent to you in the email. Please check it, the book, which is very much useful because most of the things which I covered from this book only, and it deals all the disputes of the settlement by any other means, either regional agencies or the UN Charter or the judicial decision or non-litigation methods or the diplomatic methods. These are all the things are given in this book. You can just go through it and file, which are very useful. But the entire book is not that much useful because we don't deal to that extent. We deal whichever is necessary for our study, that thing only that we will touch it. Other things just we can peripheral use it, but we don't entertain that much. Because for instance, you take here, it is given what is the outcome of the judicial settlement. What is the outcome of the judicial settlement? Generally, we follow the same, what is given by the judicial settlement, the outcome. The same thing will be binding factor to the parties. If they are not happy with, but under Article 60, it is the final, but they can approach, the party can approach for the review to the same International Court of Justice. That is only the thing. Is it clear?
It is clear, Prof.
So if you just scroll it, which are institutional arrangement, competence and procedure, League of Arab States, we already dealt it, League of Arab States, and non-legal way, the diplomatic way, how it will be resolved, we already covered in earlier classes also. And if you happen to see my earlier YouTube, and you could understand what are the non-diplomatic way, what are the diplomatic way, or in other words, non-legal way, non-judicial way. Is it clear?
Yes, Prof.
Yeah, and we dealt very depth manner the European Convention for the Peaceful Settlement of Dispute. We dealt it in a better manner, this thing. And tomorrow we will see diplomatic, in the next class we will see diplomatic way, how it can be resolved. Today we have seen judicial adjudication. Mungu ibariki Afrika, wabariki viongozi wake, hekima, umoja na amani. Hizi ni ngao zetu Afrika na watu wake. Ibariki Afrika, ibariki Afrika, tubariki watoto wa Afrika. Mungu ibariki Tanzania, dumisha uhuru na umoja wake kwa waume na watoto. Mungu ibariki Tanzania na watu wake. Ibariki Tanzania, ibariki Tanzania, tubariki watoto wa Tanzania. Asante sana, sikiliza darasa. Mungu akubariki na kukulinda.